This conference will now be recorded.
Good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our December 10th, 2020 public meeting. This meeting is being held via teleconference pursuant to Governor Cuomo's Executive Order 202.1 due to the coronavirus emergency. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of fire safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. And before we go on, I'm hearing a lot of feedback. So if you're not speaking, could you just put whoever it is, if you're a caller on the outside, could you put your phone on mute while I go on? Everyone else who's not calling, who's not participating, should be on mute. Okay, so I'll start a meeting again. I'm going to stop right now so I can put everybody on mute and just unmute the board members, and then I'll start a meeting again. 1 second. Glenn, can you hear me? Mr. Delaney, can you hear me?
Yes, I can.
Mr. Bowers, can you hear me? Tina, can you hear me?
Yes, I can.
Heather, can you hear me?
Yes, I can.
Julie, can you hear me?
Yes, 10-4. Yeah.
Amy, can you hear me?
Yes, I can.
Mr. Delaney, I'm just doing a double check. Can you hear me?
Yes, I hear you loud and clear.
Mr. Roche, can you hear me? Mr. Hernandez?
Yep.
Ms. Rajan?
Yes, I can.
Stefan?
Yes, I can hear you.
Okay, are any did I go through all the board members? Are we missing anybody from the board members or staff? I think I got everybody right. Glenn, are you there? Glenn, are you there?
I think he can hear you, but he's muted on screen. Glenn, you need to unmute your PC on the screen as well if you're dialing by phone.
Okay, so I just unmuted on my computer. Now,
Okay, you heard. I'm hearing, as long as you're hearing me, you just need to acknowledge, right?
Yes, I can hear you.
Okay, you can go back on mute if you want. Stefan is there, Amy is there, Tina is there. Do I have all the board members? I'm looking at you, but if you could just give me like a thumbs up, I can see that you're there. Can you hear me? Good, thank you. Okay, I'm going to start the meeting all over again. Good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our December 10th, 2020 public meeting. This meeting is being held via teleconference pursuant to Governor Cuomo's Executive Order 202.1 due to the coronavirus emergency. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multi-dwelling from commercial and manufacturing spaces to safe rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board rules. We will first turn our attention to a vote on the minutes of the October 22nd, 2020 public meeting. Do I have any comments or corrections to this meeting, to these minutes? May I entertain a motion to accept these minutes? Mr. Delaney. Did I see you raise your hand, Mr. Delaney?
Yes, I'll
Yes.
be happy to make a motion. I do have a couple of questions though.
Sure. Do we have a second? Mr. Hernandez? Mr. Rivera, could you please poll the board members?
Mr. Bauer.
Mr. Chair, I said I had a couple of questions.
Oh, okay, I'm sorry. Yes. Procedurally, I thought I had to go through that. Okay, good. Go ahead, Mr. Delaney.
I was just, first off, the minutes are a wonderful, accurate transcription of a thoroughly maddening meeting, given the topics we discussed. But I was curious on page 434, there are a couple of points where, Heather, your remarks are noted as, oh, there's a word that's inaudible. And I was actually kind of curious if you could recall what those words were.
Say what page again?
Page 4. In the second paragraph. You have items that require inaudible review, and then later there's inaudible full review.
Okay, go ahead, Heather.
Yes, I'm on page 4.
Yeah, page 4 at the top. Yeah.
Explain the reason that separating them would make it easier for anyone who wanted to look up definition of only one term to find it. Doesn't the administration?
I can give you a guess of what that word is. It's probably full.
It's probably what?
Full, the word full.
Full,
Right.
P-U-L-L?
F-U-L-L?
Already, maybe it's already. You have items that require blank. So in the zoning resolution, you have items that require blank review and items that can be certified in the same way.
Maybe
Probably,
full department.
probably like city review or agency review.
I think, I mean, what makes sense is a full department review. I don't know if that's what you meant. what you said. I'm sorry. Did we have an audio of the? No.
A lot of city agencies have it, Landmarks has it, there are some things you have to do through certification. It's very cut and dry, and there's like full review. Sorry, no. But yes.
Okay. I was sufficiently lost in this whole
Well, all right, so
topic that I was hoping there'd be some enlightenment there.
So it
but
says,
that's okay.
so right, the sentence is, so in the zoning resolution, you have items that require blank review and items that can be certified in some way. So yeah, I agree with Ronaldo that it's probably full review or agency review, or so the two ways that something is qualified in the zoning resolution is either it's sort of as of right, which then goes just through a standard review, or you can do a variance or a certification or some sort of a way to get it's in essence a waiver, and that would be the opposite. So it's like non-standard review. A certified review to get something certified would be a non-standard review. To get something approved without a variance would be a standard review.
Okay, thank you.
Mm-hmm.
Any further questions or comments on minutes?
And I had one other question on page 12. Acting Executive Director Lynn was going to double check on personal information with our FOIL officer. I wonder if you had a chance to do that.
So Billy, I did not do that. I thought that was subsequently resolved in the same meeting. The chairperson did correct me and say that we do redact personal information. We go on to discuss that at the bottom of page 12.
Yes. Okay, but you
It
didn't
has the information that's redacted.
double check with our FOIL. Okay, thank you.
I think I was correct. I think I used to head a FOIL unit before, so I think if the lawyers check me, right? I mean, I think stuff like your personal pedigree, that kind of stuff that is sensitive pedigree, is redacted during FOIL. Okay. Any other questions? Thank you, Mr. Delaney. Any other questions, comments on the minutes of the October 22nd board? Then I entertain a motion from Mr. Delaney to accept the minutes. Is there a second? Mr. Hernandez, thank you. And Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Rhodes,
Yes.
Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Ms. Rosalind,
Yes.
Ms. Torres,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor.
Thank you, Ms. Rivera. Ms. Lynn will now do her executive director report. I'm not hearing Ms. Lynn. I don't know if anyone else is having a problem.
Sorry about that. My phone was on mute. All right, so you should be able to hear me now, hopefully.
Yes.
Okay, good. All right, thank you, Chairperson. So the first up on my report is the governor's orders. On December 3rd, the governor issued Executive Order 202.79, which suspended the in-person meeting requirements of the open meetings law to January 1st, 2021. That's why we're able to hold this meeting virtually today. Our next meeting is going to be beyond that January 1st deadline. We expect another executive order to be issued around that time, January 1st. When we have further information, we will update the Loft Board website as well as the Loft Board listserv. In terms of revenue, the unofficial Loft Board revenue for November 2020 was $216,280. Enforcement, in November 2020, the Loft Board issued 6 violations in 4 buildings as follows. we issued one violation at 338 Moffett Street, Brooklyn, New York, for failure to provide gas. We issued two violations at 210 Crook Street, Brooklyn, New York, for inadequate heat and a missing smoke/carbon monoxide detector. We issued two violations at 255 18th Street for failure to provide gas and for inadequate heat. We issued one violation at 475 Kent Avenue, Brooklyn, New York, for improper drainage on the roof. In terms of litigation, we received one decision in two consolidated Article 78 proceedings. The caption is 470 Manhattan LLC versus New York City Loft Board. And that's New York County Index numbers 156349 of 2019 and 160119 of 2019. These two related Article 78 proceedings concern the Loft Board staff decision to hold the owner's decoverage applications in abeyance pending a narrative statement conference. Both cases were dismissed by the court, finding that the Loft Board had a rational basis to hold the decoverage application in abeyance. And that's all I have for my report today.
Thank you, Ms. Lynn. Any comments, questions for Ms. Lynn? Thank you. So we have, there's only one case on the calendar today. It's a master calendar case, right? And it's Wang and Associates LLC. And that address is 145 Grand Street in Brooklyn, New York. And docket number is FO0851. Board members, do I have a motion to accept this case? Mr. Barwitz, is there a second? Mr. Delaney, do we have any comments on this case? Mr. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Ms. Roseman,
Yes.
Ms. Torres,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor.
Thank you. So moving right along, the primary purpose of us being here today is for rulemaking. And Mr. Clark, I'm going to turn this over to begin the discussion. Ms. Lynn, before we turn it over to Mr. Clark, did you have anything in particular, or Mr. Clark will handle?
I think Mr. Clark will cover it.
Thank you. Mr. Clark, you're in the hot seat. Thank you.
Thank you, Chairperson Hilton. I just want to make sure everybody can hear me. If you can just give me a little wave. Can you hear me? Okay. All right. Thank you. All right. So we're going to be discussing the two Word documents that I sent over to everybody. The first Word document starts with section 1-12 definitions. And just to give you a quick overview of what each of these documents are, the first document they are the comments that we received from Oath. We're just going to give you an update based on what we discussed in our board meeting and the response that Oath gave back to us. So we'll give you an update and let you know what Oath has recommended with respect to any of the rules that relate to Oath. The second Word document that we have, that's the law department's comments. These are new comments that we're going to be going over today. Hopefully we can get through them. And in between those documents, I sent an email, I believe it was late Tuesday. We got some comments back from the law department with respect to the quorum. Hopefully it made things a little bit more clear with that confusing rule, but we'll discuss that before we start talking about the law department comments. So with that said, I'm gonna start discussing the first document, and that's the comments that we received from Oath. So the first comment is under section 1-12 for definitions, and the Loft Board made some corrections or with how we're going to define adjudicator, and the Oath responded saying that they're okay with the way that with the changes that we made for that definition for adjudicator. So they were fine with that. The next thing that we discussed was 1-27 for the hearings. And that was Mr. Delaney wanted the law board staff. So basically, again, that section was, it says where oath conducts a hearing and the law board rules conflict with oath procedural rules. Oath's procedural rules or practices will apply unless otherwise provided by state law. So Mr. Delaney wanted the law board staff to do some research to find out if there are any conflicting procedural rules between oath and the law board rules. And we're in the process of going through oath's rules and the law board's rules to see if there are any conflicting procedural there's any procedural practices that are conflicting. So we will give you an update as soon as we're finished with that. I don't know why it got very dark in here, but hopefully you guys can still see me.
I'm seeing you, yeah.
Okay. Okay. So the next thing is.
1 second. Mr. Delaney has a comment.
Oh, I'm sorry, Mr. Delaney. Go right ahead.
Just on that point, I want to thank you for undertaking for taking the time that it will require to follow up on my request. I have also spent some time with the oath rules, and one thing I would point out to my colleagues, I don't have them in front of me at this particular moment, and I don't want to waste your time while I rummage around for them, but in addition to its general rules that are in the first several sections of oaths rules for procedure, they then have separate sections that apply to additional rules for specific kinds of things that oath does. For example, like Article 4 or Section 4 or 3 is specific rules for impounding vehicles. And there are, it does appear that oath is recognized in general that some of the things that they do require specific rules. So why our procedure and theirs needs to be seamless is even less clear to me now than it was before.
Thank you, Mr. Delaney. Like I said, Mr. Glenn Argov, he's actually doing undertaking that task. So thank you very much, Glenn. I know that's keeping you up late at night. So thank you. So we'll go on to the next.
It's like the newest member of the Supreme Court has to get up and close the door, right?
Exactly.
Glenn has agreed to get this done before Christmas, right, Glenn? Yep. Okay, you said yes. Good.
Okay, so the next section on this sheet is section 1-30 with respect to the settlements. This is some new language that Oath brought back to the Loft Board. We wanted you to take a look at the way that they worded this particular rule. Again, this issue was the issue with the remand. You're going to see this in 2 other sections on this worksheet, but this is the first time you're going to see it. And the Oath made modifications on how they want to word if the Loft Board needs to seek a remand. Here, they don't want to be told that the board can just remand any case. So the way that they worded it now is the Loft Board may direct its staff to reopen a matter for further investigation, or where the Loft Board determines that the record in the underlying proceeding has not in whole or in part been fully developed, the Loft Board may refer the matter back to Oath for development of a complete record. So that is the proposed language that oath has for this particular section in our rules. And we would just like to get the board's feedback on whether or not they think this wording is fine. The law board staff has reviewed the language, and we don't take any issue with this, but we would like to get any comments back from the board members.
And to be clear, that's replacing the line that reads, the loft board may direct that a particular matter be reopened and remanded for further investigation.
That's correct.
Thank you.
So are there any comments with the way that the oath would like to word this part of the rules?
How would you summarize the changes in layman's terms, Mr. Clark?
I would summarize it by saying, first, the law board can't directly tell oath that they can remand, that they have to remand the case and hear it over. They have to request it from oath. The second thing is, what oath is very concerned about is not listening to a case and going through an entire record over again and wasting resources. So basically, this language appears to us that when they do undertake, when they do review a case over, it's to complete the record. There has to be something that was insufficient in the underlying record that they're going to take the time to go back and try to complete the record so that the fact finder can make their decisions based on a complete record. So I think that's the basic gist of what oath is saying here.
And if I may just add something to that, Mr. Clark, I think oath's drafting is intended to clarify what we in practice already do, and that, if we have a legal disagreement with dispute, if we disagree with oath's outcome, we don't remand it back to oath. And that's what they're trying to prevent us from doing, because it doesn't really make any sense for us to do that. But if the factual record is insufficient, we can and do remand it back to oath. So I think that's what oath was trying to do, to clarify what the existing practice already is.
Yes, and I would also add, Acting Director Lynn, that from what I understand from oath, this is the standard language that they've been using with another agency as well. So they just basically copied the same language that they've been using with other agencies, and they're just putting it here with the law board.
So if I understand correctly, whereas the previous language that we discussed from oath basically wouldn't allow any kind of remand, this addresses the fact that they will accept something referred back to them if it's a question of the record not being fully developed.
Yes, and just to clarify, oath didn't say that we couldn't remand back to them. They were just saying that we can't demand that they take it. We can only refer it to them, and basically they want the leeway to make that decision for themselves.
In other words, Mr. Clark, are they hung up with the fact that we're not a higher court?
Right. Okay. So are there any other issues or I'm sorry, somebody saying something? Are there any other issues or comments with this this language that oath has now included? No? Okay. So we're done with that. Okay, the next section is 1-31 for decisions. And this was originally oath took out the words So I'll read the entire section. It says, actually the sentence about the report and recommendation. The report and recommendation shall be based on the administrative record of the case and relevant authority, including but not limited to Loft Board orders, decisions of courts of competent jurisdictions, statutes, and rules. So we included Loft Board orders, but I made a mistake, and the board member, after I read the minutes, it should be the board requested the language Loft Board decisions, not Loft Board orders. So I want to bring that to your attention. But Oath was fine with adding Loft Board orders. So I don't think that they will have a problem with switching orders to decisions, which is what the board had originally said. But I just wanted to bring that to your attention. We would be adding back in Loft Board decisions.
Before you do that,
I would ask the board members to consider sticking with Loft Board orders. That is the official orders issued by the Loft Board. I think decisions might open up to some questions. I think Loft Board orders is probably a better usage.
I was going to say, I think your orders are your final decision. So that's actually a much more precise word.
Okay. Are there any other comments? Oath was fine with adding Loft Board orders into this definition. They originally took out Loft Board decisions, but they're fine with adding back in Loft Board orders, and that's the way that it would read now. Are there any other comments on this?
I think orders is just as good as decisions and probably more precise.
Okay, great. So we can leave that. So that's fine. The next section is also under 1-31 decisions. This is for the report and recommendation. Mr. Delaney wanted to see if there are any differences between the report and recommendation requirements in this section, section C, and what Oath is currently providing in their report and recommendations. So we have not gotten to this part yet for doing the research, but I know that Mr. Delaney also was doing some research, but we still have to get to this part here where we need to find out if there are any differences between the report and recommendation requirements in this section and what Oath is already doing.
Is this tied in with what our attorney Glenn is doing?
No, this is something different.
No, I haven't asked Glenn to do that. We'll work that out. I don't know if they'll be ready for January. We do have Loft Board orders to focus on as well. But it's on the horizon.
Okay. And so the last page, or there's only 2 pages, so page 2, is section D. At the October meeting, the remand issue came up, and Mr. Delaney questioned whether there are any other sections in our rules that spoke about a remand. Oath didn't comment on them originally, but we went back to Oath and asked about the other sections that talked about remand and asked them if they had any comments on those as well. And Oath did come back and they made changes to section 1-31 decisions, section D. And they also took out the word remand and included the language that was used in our summary cases, very similar, but it reads, where the Loft Board determines that the record in the underlying proceeding has not in whole or in part been fully developed, the Loft Board may refer the matter back to Oath for development of a complete record. If the board refers a matter back to Oath, Oath shall issue a recommended decision at the conclusion of the additional proceedings. So the language is very similar to the language that oath wanted to use for the summary cases. These are this is the language for the master cases where reports and recommendations are written by oath. So we just wanted to bring this to your attention and find out if there are any comments with oath's change in section D. Any comments? Again, it's basically oath wants to develop it. Basically, oath will if we refer a case back to oath, it's so oath can develop the underlying record so that the fact finder can make a thorough decision on the underlying record.
It looks fine to me. I mean, it seems very close to the other section there, so it's pretty good.
Okay.
So the additional language is kind of replacing the word remand, right?
Yes, exactly. Okay. Mr. Barrows, I don't know if you had a comment. Thought I saw your hand, but I'm not sure.
No, I seem to be fine with this.
Okay. All right. Okay, so finally, the last thing on this sheet is section 1-32 for reconsideration of law board orders. Again, this is where oath caught the word remand again, and they took out the word remand and replaced it with refers the matter back to the adjudicator. So they're just replacing remand with refers. And we wanted to bring that to your attention. If there are any comments, we can go ahead and field those comments.
They've sanitized by taking out the word remand, but the last word in the sentence is remand.
That's true.
Well, we could assume that the word will be referral, right?
Yeah. Following the referral, probably.
Well, why don't we let them figure out what they mean? They're certainly not good proofreaders or copy editors.
But we're not going to go back to them on this. If they have any objection when our rule gets published, they'll. So, board members, are you satisfied with just replacing that last word with instead of remand, but to terminate final age determination following the referral? So why don't we change, Mr. Clark, that word just to referral in our rules? Okay. So please do not go back to oath with this.
Okay.
I don't think it's unless anyone else objects. I mean, I think makes sense, and it wouldn't be something that even if you went back to them or they found out, it would be objectionable.
Okay. So we'll go ahead and do that. If there are no other comments, then we're done with this page, and we can go on to the second page.
So before you move on, Mr. Clark, can I just clarify on these two pages, what are the things that are still outstanding? What sections? Just a clarification.
Okay. So just for clarification, section 1-27E.
E, right? E?
Yeah. Yes, E. E is an egg. And also 1-31. C is in Charlie.
And those are research questions, right? Not language, right? Just research questions?
Correct.
Thank you.
Okay. So the next sheet we have, actually before we go into the next sheet, I'm sorry I didn't have time to print this out, but it's actually the email that I sent everybody with respect to the quorum. I hope everybody had time to read over it. It is section 1-18 in our rules. And in the email, I sent our current language, and I also sent over the proposed language from the law department. If there are any comments or suggestions from the email that I sent, we can discuss that now.
You kind of have to put it on the record, Mr. Clark. I mean, if you don't have it, I mean, can you just read what it says?
Sure. All right. So this is the discussion, the comments that we received back from the law department regarding the quorum. And it says, board members, as you recall, a quorum is the majority of the entire board. When counting the entire board, the law department stated the count is 5 plus currently serving public members. In other words, the public members are anyone who isn't a commissioner or one of the 3 specific interest representatives. So that's how we count the entire board so that we can determine if there's a quorum. Again, that's 5 plus any currently serving public members.
In other words, Mr. Clark, I just want to, for the sake of, because I really got this kind of light, you know, like an illumination came to me when I was reading this, that we don't have to, you know, we're stuck. I mean, there's five people are always members of the board, right? Those are the 2 ex officio members and the 3 specific interest members. That is the public, the tenant, the owner, and the manufacturing representatives, right? Plus the 2 ex officio members, myself, the chair, and the fire department commissioner, represented by Mr. Roche. So those 5 people must be, right, in terms of getting a quorum, even if they're vacant, they must be included, correct?
Yes, in the count?
In the count when you're establishing a quorum. So you always have to have 5 people. So there must be,
yes,
the number, start with the number 5, and then you add any additional public members to the board to come up with a total, right? And then you divide that by 2, and if you have a number that's bigger than the half, then you have a majority, correct?
That is correct. That is correct. So those 5 will always be included in the count when you're counting the entire board. And then you add any currently serving public members, as Chairperson Hilton said, accurately said. Are there any comments with that, or with respect to that? Does that make it a little bit more clear for everyone how to count the entire board and establish whether or not we have a quorum so that the board can take action?
So what's the maximum count? Is it 5
The maximum?
plus 2 plus 3? That's, sorry.
No, you can't say maximum. Well, there is a maximum, but right now we're trying to establish what the minimum is for a quorum, and that's
Okay.
the number 5, representing the 2 ex officio and the 3 specific interest representatives. That goes to 5. So it doesn't even matter if there's a vacancy. If any one of these positions, you must use those numbers in determining a quorum. They must be included. So we start with simple math. We just start with 5, and then we add public members.
I've read this over 3 times. It's not, you know, it's not any clearer than what we had before. But, you know, as I've said before, it seemed off base, but that's the way the state runs, and that's the way we're going to have to do it.
Well, this is something that the law department is fine with, right? So, you know.
Yes.
Okay.
But
Go on, Mr. Clark.
Okay, so the next part of the
Oh,
email.
I'm sorry.
I'm sorry.
Sorry, I thought you were going to make another comment on A. We devoted 5 pages of the minutes or thereabouts to the question of special interest versus specific interest. Ronaldo uses the term specific interest, but I see here in the law department, it's still special interest.
My mistake, yeah, whatever it says there. Yeah.
And as I
No,
recall,
just for clarification, Mr. Clark was going to get to this, I think, but law department did approve of the use of specific interest, so we can go ahead and correct that in our rules.
Because as I recall, the question came down to, was it in either of the executive orders? Because the term special interest is not in the state law.
What is in the state law?
The state law just says individuals representative of. It doesn't use either specific or special.
Mr. Delaney, you are correct. We went back to the law department on this, which again, I think Mr. Clark was going to get into at some point, but we did ask the law department, and I believe the conclusion of the last board meeting, we were going to ask if we could use specific interest instead, and law department said that was perfectly fine. So we can go ahead and start using specific interest and not special interest going forward.
So should we change the underlined paragraph for the new A to specific at this point, or no?
Yes, we can change that. Going forward, you shouldn't see special again in any redraft. Specific.
Well, I just thought special was so much better, but that's all right. Oh, it's special. Everybody's special. I'm joking.
Okay, so if there are no other questions, I'll go into the next part of the email. And that was a question that Mr. Delaney had with respect to the vacancies on the board versus board members that are absent. And the law department said, the special legal counsel law board rule requires that 5 statutorily required members always be counted with the public members, to be counted unless there is a vacancy, in which case they are not included in the total. So if the public members, for the public members, if there's a vacancy, they are not included in the total, is what we discussed earlier. So the law department went on to further say, merely being absent is not enough. That is the purpose of the quorum rule, namely to determine whether business can be conducted when a member is absent. So they clearly differentiated counting a quorum in which you take the vacancies into consideration, and basically the reason why we are actually even finding out if there's a quorum is to find out if business can be conducted. So once we determine that there is a quorum and business can be conducted, then we would go about and vote on cases and minutes and things of that nature, and then that's when absences would come into play. But with respect to finding a quorum, only the vacancies are taken into consideration and absences are not taken into consideration. So hopefully that was answered Mr. Delaney's question. But if any board members have any questions about that, then we're available for discussion. Discuss it. It's pretty clear.
So what we're going to do, if I understand correctly, is take this new language from your email that's underlined and put that in as the new section B.
Yes, that is what the
No,
the
I
law
don't.
board can.
Mr. Clark, wait, hold on a second. I think a lot of what's in that email is just for the point of clarifying for the board members what a quorum is. The law department isn't actually suggesting a change to the rules. We just wanted to ensure that the board members understood how they calculate a quorum. That was the purpose of that email.
Okay. So
Okay, but now you've got me confused. In Mr. Clark's email, it says for current proposed language in black, changes in red. So we have a B that's not underlined, and that is I printed it out in black and white, so the red part's lost on me. We have a B.
Yeah.
We have a B that isn't underlined, and a B that is underlined. And if I recall my red and
I
black,
misunderstood what you said. I thought you were referring to the language that Mr. Clark was reading out before from the law department's emails. But you are correct that in his email, he does reproduce the proposed language change again. So anything that comes after 1-18, he did reproduce the rules in his email.
Right. The commentary at the top of the email, I understand, is not going to become part of the rule.
Right. That's not, yeah, the comments at the top would not be part of the rule.
Yes.
Okay. So,
but I do have one more question. The in that top part, the law department responded as follows: the special legal counsel loft board rule. I have never seen the term legal counsel loft board rule before. Does that refer to, it seems to refer to something specific because it's capitalized.
Right. I saw that as well. It didn't strike a chord with me. I've never seen that before. But I'd be happy to double check and find out if that was just an error or if that really is something. Special legal counsel loft board rule.
It could be like double secret probation.
There goes that special word again.
It should be specific.
I guarantee you, there's no such person or rule. But Mr. Clark, yeah, maybe they meant something different. Maybe they're saying the legal counsel's direction or so requires that. But
that was my interpretation of the email, but we could clarify.
Thank you. That would be very helpful because if there is a special legal counsel loft board rule, I'd sure like to know about it.
Yeah, of course.
Sounds like a federal position.
I think the law department was referring to a specific person at the law department who opines on such matters and who gave direction on what it should be. I thought that's what they were referring to, but I think it's just one person's opinion who happens to be very knowledgeable in this area. But we will double check and see what they meant.
Thank you.
Okay. And with that being said, we can go into the second page, which says law department comments for the board review. With today's date on there. And
second page of what?
The second Word document, I'm sorry.
Oh, okay.
I'm sorry, what about, we discussed A and B. And with regard to C and D, there's no.
Oh, I'm sorry. Continuing the discussion on the quorum.
Right.
Okay, I'm sorry. Are there any other comments with respect to the language that the law department suggested for the quorum? Do I need to read that into the record, Chairperson Hilton?
Yeah.
The rules, the current proposed rules and the changes that the law department suggested at the bottom of the email?
Ms. Lynn?
So yeah,
Could you kind of give me some legal guidance there on that? Do we actually need to read it in the record, or could it just be a part of the record?
I don't think so, because we have not been reading every single rule that's discussed into the record. All of this is for the board members to review, and the public gets a chance to review it when it comes time for them to comment. So I don't think it's necessary, but certainly the board members could decide to read it out loud right now if they want to.
I was just trying to ascertain what was different between, remember, we only got this at 2 o'clock yesterday. So I was just trying to ascertain the difference between the C that's in black and the C that's red and underlined. And as far as I can tell, the only difference is that they put in a parenthetical numerical one and then trimmed, taken out Department of Buildings and Fire Department, or department, made it just Fire Commissioner. They've just taken out a few words, but I want to make sure I'm not missing anything.
I don't believe you are, Ms. Delaney. This rule was, well, first, this rule is the same thing as the last version that we looked at during the last board meeting. The only purpose of this email was to clarify the questions the board members raised at the last meeting, which was to address the quorum issue and the specific interest issue. So nothing's changed since the last time that you all looked at it. And as for the difference between this and what was different, all it was, the major changes are in the first two paragraphs, I believe. There's an addition of paragraph B. I don't believe that was in the original February draft version of the rules, but that is the only difference.
They also added the word majority before vote.
Right, right.
Yes. Yes.
And once again, we still have our special interest groups. Hard to get rid of them.
Yes.
That will all be corrected as well.
Thanks for picking that up.
Okay. Are there any more comments for this section? Okay.
Maybe we should just read that out loud at this point, like the executive director was suggesting, because no one can see it and we've been talking about it. Should we just read C and the two C's?
I'm sorry, somebody else is on the record. Okay. 1 second.
Okay.
Board members, someone else is on your record. Okay, good. Go ahead. Ms. Torres, are you saying
I was just saying, I heard
you would like us to read that section C on the record? Just
yes.
read it out so you can see it? Okay. Mr. Clark, go ahead.
Sure. And did you want me to read the current proposed rules and the changes on the record, or?
Just read section C from Ms. Torres. The new C.
Right. The new C. Okay. So this will be section 1-18C, and it will read, each member of the law board has 1 vote. The commissioner of buildings and the fire commissioner serve ex officio, may each designate an employee of his or her department to serve on the board and vote in his or her absence. Representatives of the special interest groups may, in their absence, designate, I'm sorry, it's going to be specific interests with the change. So I'll read that sentence over. Representatives of the specific interest groups may, in their absence, designate substitutes to participate in discussions at the Loft Board meetings when the Loft Board, by majority vote, requests such participation. Such designated substitutes may participate only to the extent permitted by the Loft Board and shall not have the right to vote.
Okay. I remember this whole thing quite well last year. So, and you said the word majority was added in, right?
Yes, in front of, yes, it was added in.
Yeah, it makes a lot of sense, right? I think it makes a lot of sense that if you're going to do a vote and permit something, it has to be a majority vote. Okay. Thank you, Mr. Clark. Move on.
Okay, so now we have the other document. And these are the law department's comments again. We'll start off with section 1-12 in the definitions. So the issue here, we have two global definitions, one for family and one for family member. The law department is concerned that the definitions of family and family member are inconsistent and they're not clear. So when the law board staff looked at it, we can see that we think the definition for family, the definition for family comes from the MDL and relates to coverage. And the definition for family member comes from rent stabilization and relates to protected occupancy. Two totally different issues. So we agree that this increases the difficulty in finding consistent language for the two terms. Family member only appears in our rules in the succession rights and under abandonment. And under the abandonment rule, it says no family member, as long as no family member is denied succession rights. So that's where family member comes in under the succession rule. So we think we can remove the global definition of family member and leave the definition for family member under succession rights, under the succession rights section. So we just wanted to bring that to your attention and see if the board is fine with us removing family members from the global definition and just leaving it under the section for succession rights. Are there any comments? So is everyone okay with us removing family member from the global definition?
You're saying it fits, go ahead, Mr. Delaney, I'm sorry.
And presumably, when you move the family member definition to the succession rights portion of section 2, you would add some language like as used in this section, family member means.
Right, it's already there. So if I misspoke, then what we would be doing is just removing it from the global definition and just leaving it as is under the succession rights section.
Got it.
So if everyone is fine with that, then we can move on to issue number 2. That is also in the definition section. And it's IMD, definition of IMD. So the law department does not think we need in our definition for IMD. I'll read what our proposed rule says. It says IMD means an interim multiple dwelling as defined in MDL section 281 and section 08 of these rules. So the law department does not think we need section 08 of these rules. The reason being is because although IMD is mentioned many times in our rules, it is never actually defined in our rules. Our rules define IMD, and when our rules define IMD, we always refer back to the MDL, if that makes sense. So the law department is saying your rules actually don't even define IMD, so just take out as defined in section 2-08 of these rules. So the law board staff thinks that it's fine to take out in section 2-08 of these rules.
I think that makes sense too. This is Julie speaking. I think sounds right.
Right, are there any other comments?
So that would mean that there would be a period after as defined in MDL section 281.
Yes. Okay. If there are no other comments, we can move to item number 3. Item number 3 is just an update on a comment that the law department made and what the law board staff is doing. So the law department made a comment under the definition for special permit. They wanted to know if there specifically what other agencies have jurisdiction to issue special permits. So right now we know that city planning can issue special permits, but we're researching what other agencies specifically can issue special permits, because we believe the law department just wants to delete that language. If there are no other agencies that can issue special permits, they think it's unnecessary to have that language, any other entity having jurisdiction. So we're doing the research.
But Mr. Clark, I mean, city planning landmarks is not the same as city planning, right?
Is landmarks the same as city planning?
It's not, right? I mean, as far as I know, the landmarks is a separate
Yeah,
entity, right? So I know for a fact, Mr. Roche, maybe you could back me up here. I mean, landmarks does give special permits. Roche? And maybe,
I'm thinking, I'm not,
I'm thinking maybe the fire department gets special permits for certain things, but I'm not sure as far as this goes, what's wrong with just leaving it there? I mean, what they don't want to, I just don't feel comfortable taking it out. What if tomorrow it changes?
That's a good point. If it changes in the future, then
right. I think that's a very picky comment, you know, whatever from them. Board members, I would just leave it there.
I agree with you. I'm just thinking through. I'm doing a project through DOT and wondering, you know, DOT in relation to MTA and DB. You know, like it seems like there are other jurisdictions that could have. Maybe it's not called special permit, but something else.
Yeah. What?
Sorry, there's like a word, but
What is going
back. I'm going back on mute.
It's like a frog sound.
Yeah. Board members, could you just everybody go on mute for a second? Just everybody go on mute. Okay, so board members, you can take yourself off mute. Whatever it was, stop. So someone.
Yeah, sorry, that was distracting. The frog threw me off. I was trying to say that there's other special permits, or maybe it's something close to a special permit that you just get permissions from different agencies. So I agree with you, Ronaldo, that I don't, like, I would rather have this in there than to take it out.
I understand that they need to conserve on words and stuff, but I think it's picky to be saying or any other entity having jurisdiction. It's very tomorrow. You know, there could be another agency that comes up and have jurisdiction. So, okay, Mr. Clark, we're going to leave that.
Okay. So the next issue is issue number 4. That's in 1-26.
Mr. Clark, you're coming in muffled, and I think with the issue that we're having is with your phone.
Oh.
So could you do me a favor? If you're on your laptop, could you dial in so we can have a separate voice line?
It did sound like when he started speaking, the frog came back.
That's right. So it may be your device.
Okay, I'm gonna put myself on mute briefly and call in. Sorry about that.
Okay, that's it. I think it is. So just give Mr. Clark a second to dial in separately. Let me know when you dial in so I can just identify you. Mr. Clark, I can actually provide you a phone if you want. I know you're right next door, so I can actually join a meeting for you and give you this phone if you're having a problem.
Mr. Chair, it's closing in on 3:30. Can I suggest maybe we take a 5-minute break while you folks get the audio?
Sure. It's a good idea. Thank you. So this and just so you know, the recording is not ending. So please, everyone, just put your phone on mute, and I'm going to adjourn for 5 minutes. Thank you.
Hi, can you hear me? Can you hear me? Just me. Okay. Actually, I'm gonna use the bathroom really quick.
So board members, whenever you are back, and you could just indicate by coming off your mute, just let me know that you're back so we can continue.
Hi, can you hear me okay now, Chairperson? Listen.
Okay. When you get a chance, check your laptop. There's a frog in there. Okay, I think we have a quorum. I think I see 5 board members. So, Mr. Clark, could you just continue your discussion?
Sure. Can everybody hear me now? Okay. Okay. Great. All right. So we're now on issue number 4. And in this section, the law department. So the comment that the law department made is we're talking about the narrative statement conference. And so for the board members that are not familiar with the narrative statement conferences, that is actually when one of the Loft board staff members, we have a conference with the representatives from the owner and the tenants, sit down in a room and we discuss the owner's legalization plan, how they're going to go about legalizing the building and the individual IMD spaces. So those are the narrative statement conferences. So oath, in section 1-26 communications on pending applications, section A, the last sentence, it says Loft board staff conducting narrative statement conferences may communicate on substantive matters with one party without notice and opportunity for all parties to participate in order to facilitate reaching consensus on a legalization plan. Oath's comment was that this type of communication is not permissible. So what the Loft board staff said that, in our opinion, we believe the narrative statement conferences are not pending applications. So when we do have these conferences, we do have the leeway to speak to one party without notifying the other party, so that we can see if we can try to get an agreement between the two parties. So we think the law department might be confused because also we think the law department might be confused because this language is under pending applications. So with those two things, our suggestion is we can make a separate paragraph in this section after section C, and we can make our own D. And in that, we can add this language so it's separate and apart from the first part of section A. Basically separate it. Because we do want to allow staff, whoever's conducting the narrative statement conference, to have the leeway to speak to one party without notifying the other party, because we don't feel like this is a substantive matter, a substantive legal issue. We're just discussing the legalization plan. So our two suggestions was, one, to make a separate D and add that to the bottom and put in the language, the Loft board staff conducting a narrative statement conference may communicate, and finish up that sentence. Or alternatively, we can take out the language for now and add it in when we revise chapter 2. So just to make it less confusing, that the Loft board staff member conducting the conference is not doing something impermissible, we can either take out that sentence and separate it and put it at the end of the section, or we can just remove that language altogether. I know that was a little bit confusing, so anybody has questions, I'll try to clarify that as much as possible.
Yeah, I have a question. I'm wondering, what's the current version of the law say? Does it have any mention about this?
I don't think. I think we just added that. But let me just verify. This is added language.
Yeah, I don't understand why we would have added that language here in the first place. I mean, it's nice, but why would we have added it here? You know?
I think that's one of the reasons why the law department is confused, because it's literally under
Pending notification.
pending application. So
Yeah.
I'm not sure where we would put that in, where else we can put that in. We thought about putting it in under in chapter 2 when we talk about the narrative statement conferences, and that's why option 2 is to take it out now and add it when we're doing revisions to chapter 2.
Does anyone remember any debate on this issue as to why we put this in there? Anyone? Go ahead, Sean.
I can tell you that a number of years ago, before Helene became the executive director, there was one group of tenants in particular who complained to me vigorously that the executive director before Helene had been speaking with the tenant's landlord in the context of a narrative statement conference, and felt that that was, shouldn't be permitted. And as we know, there are a significant number of changes that we're proposing in chapter 2 to the narrative statement process. There have been comments and requests from the tenant community that the board go further than what's currently proposed with regard to creating a summary of the narrative statement conference, because what happens now is sometimes the parties go away with different understandings of what was accomplished. Neither side is allowed to record the proceedings. So whether we take this out now from here, and I think creating a new section under pending applications wouldn't be very helpful, because the law department is going to still think of it as an application. So there have been instances where the fact that there are ex parte conversations have led at least some tenants in certain groups to question the fairness of the narrative statement process. I understand the arguments for it, but there are some arguments against it as well.
Thank you. Thank you. So this language actually is just kind of making it formal anyway, right? The ability for us to do that. So correct me, Director Lynn, but we do conduct some conferences with either side, right? Separately, sometimes, just to get things moving. Do we do that?
Maybe on very, very rare occasions. We certainly will have conversations with one side about a certain issue when they reach out to us. You know, it's not like we hang up the phone and say, we're not going to talk to you. But we very rarely, I believe, and maybe Mr. Clark, who handles more of these conferences, can speak to that. But we rarely have a formal conference and legalization plans with one side only, mostly because it's not productive. But we would like to leave the option of doing so open. There are some instances where it's helpful to have a sit down with just one side and not the other, but it happens very, very rarely.
Right. All right. So I suppose Helene may have felt that we needed to formalize that in the rules by putting the language here. Otherwise, we could just not have this language, right? And
yeah, I just wanted to say one thing. So we agree it shouldn't. We agree with the law department. It should not be here, and then putting it in chapter 2 or elsewhere. It was good to hear from Chuck. I'm just concerned that codifying it into here, like, encourages it to happen more if you're saying it happens rarely. So I just want to think about that some more. I wouldn't want a party to start using that, more, like pushing that aspect because it's written in a sentence now. I don't know, because I've been through the narrative statement and I like the narrative statement process. I would not want it to become more about one party getting to talk to someone than another. So.
Okay.
I think,
Anyone else?
and I wasn't, sorry, I just want to add to, so I think the intent behind this was to foreclose legal avenues for someone to challenge on occasions when this does happen. If a tenant or an owner wants to discuss a matter with a law enforcement staff for whatever reason, we don't want the other side to come back later and undo the entire process by saying you shouldn't have done that, because this isn't an ex parte communication and it's not an application. There's nothing to stop us from doing such a thing. So, and I would say that the parties can push however they want to, but at the end of the day, it's going to come down to the discretion of law enforcement staff to do, what we feel like is fair. And, in my experience, at least so far, I feel like the staff has been very fair to both sides. So I'm not particularly concerned about, giving one side more of a voice than the other. Okay.
Is there a section dedicated in the rules to narrative statements, right?
Yes, that's under 2-01. The issue here is that the current revisions of 2-01 are not quite up to par. The entire Chapter 2 requires significant revision. It would be quite challenging to find a place to insert it into Chapter 2.
Heather, are you going to say something? Heather, you have to,
I was just adjusting my screen as the light's changing and the glare is changing. Sorry.
Okay, all right, great. Does anyone else have any comments before I say something? So I'm just thinking we should take this out.
Yeah, it is definitely a strange place to put this. And we agree that it could potentially cause confusion.
Okay.
Mr. Barrowitz, I saw your hand.
Mr. Barrowitz, yeah, Mr. Barrowitz, you're going to say something.
No, I just said I agree. We should remove it. This makes things more complicated.
Anyone else?
So for whatever reason, the highlight includes the last word of the prior sentence, participate. But I presume what we're going to strike is begins law board staff conducting narrative statement conferences.
There are two highlights there. I think that highlight was one that was done by the, who is SC?
Oh, that's me. I'm sorry. Yeah, that was
Okay,
just
my
own comment.
So you just highlighted the wrong. You just highlighted the wrong word, but
Yeah.
you're right, Mr. Delaney. The highlight that they're talking about starts with Loft Board and ends with plan. Okay, board members, do we have a consensus? So we move on. We just remove this for now. Mr. Clark, could you just park that language somewhere in for chapter 2?
Okay.
Let me get to it.
Yeah, we'll figure out where that goes when we get to chapter 2 under the narrative statement process.
If it at all, right? If at all. Okay, thank you. Okay.
The next item is item number 5. This is under 1-27 for hearings. This was just a comment from the law department. They wanted to know what adjudicative duties the law board staff has as attorneys. And we clarified with them what some of the other adjudicative duties that we have. As attorneys, we do propose orders and do legal issues, and we are on that legal side, but we also conduct narrative statement conferences, issue certifications, letters of no objections, and lip holds. So we just clarified that with oath. So
Oath or law? Oath?
I'm sorry, with the law department. I'm sorry. Yes. So we're just waiting for a response. Actually, no, we got the response from the law department. And the law department said that they suggested a sentence that we could put there. But at the end, they said, so I'll read what they said. The law department commented recently. It says, the sentence they suggested is, where a hearing is conducted by a Loft Board staff member, such staff member will not be assigned to any other duties relating to such hearing. That was a sentence they suggested adding in there. But after that, the law department says, but it sounds like the rule is intended more for internal hearing management rather than for the benefit of the hearing participant. So precise phrasing probably isn't necessary. So that was their response when we explained our adjudicative duties. That precise language there is not necessary, but they gave a suggestion for a sentence that we could put in there, add in there. And I'll read it one more time. It says, where a hearing is conducted by a Loft Board staff member, such staff member will not be assigned to any other duties relating to such hearing.
Huh? That's confusing to me. Anybody else? Because I mean, it seems like when a hearing is assigned to a Loft Board staff member, such staff member would not be assigned to any other duties related to such hearing. I don't understand that piece.
Yes.
So, am I alone?
I think the way I interpret it, but I'm not a lawyer here, is that they were afraid that someone's representing an individual and then turning around and also being like doing double duty, like being representing them as their lawyer and then.
No, but this is the Loft Board.
Right.
A Loft Board staff.
Mr. Clark's second sentence from the law board, they kind of corrected themselves, I feel like, in the next statement. So to me, it makes sense it's okay to leave it as is.
That's what I'm thinking.
Yes. I think so as well.
How come it switches from adjudicative to administrative?
Oh.
Mr. Rajan, so are you referring to the language that we already have, or the sentence that the law department suggested?
That's where it switches, right? So this original one is the one that says adjudicative?
Adjudicative duties, yes.
Okay, so then this other stuff that's underneath it, where administrative, just ignore that. That was a mistake. What they're really trying to say is that sentence that you read out?
Yes. Right.
Okay, yeah,
Because
no, I agree with the chairperson. The new sentence doesn't make a lot of sense.
Right.
Okay.
But Ms. Rajan, were you suggesting to change the words adjudicative to administrative?
No, not if that's what the idea was. If the idea is to leave it as adjudicative, I just got confused with this other stuff that's in here. But if that stuff is irrelevant, I could ignore it.
Right. I would do what the law department says, leave it alone.
Right.
Yes.
Okay.
Certainly not using the language that they proposed. This is it's even more confusing.
Right.
Okay. Okay. Great. Okay. So turning to item number 6.
Boy, wait a minute. Before we go on,
I'm
let's just
sorry.
be clear. What is it we're trying to accomplish here?
The
But
rules.
not to make the law department happy, but what it's my impression that what we're trying to say is if a law board staff member is conducting a hearing, which currently isn't happening for the most part, correct?
At all?
Yes.
Right.
That's correct.
But if there comes a time in the future when a law board staff member is conducting a hearing, we wouldn't want that law board staff member involved in any other aspect of that building's activities.
That's correct.
So if I were having a coverage hearing, I couldn't also preside over the narrative statement conference.
That's correct.
But if I were having a coverage hearing and I needed to mail out notification of an adjournment, I could do that.
Yes, that would relate to all aspects of the adjudicative duties that that staff member would be responsible for. So yes.
Which would include some duties that one would deem administrative.
Or adjudicated.
Right, I see what Mr. Delaney's saying. Mailing out notices, one might argue, is administrative as opposed to adjudicative duties.
But where is the word administrative here?
Administrative, that comes at the bottom when I was just discussing what the law board was trying to explain to the law department. We're trying to explain to the law department that as lawyers, we also have administrative duties as well. So the law department was confused in that sentence where it says, our rules currently state where a hearing is conducted by a law board staff member, such staff member will be assigned solely to adjudicative duties. So the law department said, as opposed to what? And we explained to them that we have more than just adjudicative duties. We have administrative duties as well.
Okay, so but we're not, yeah, I hear you. So listen, I don't want to, with all due respect, we're not doing this right now. It doesn't seem to be consequential to anything. And it seems okay that if you're mailing out envelopes to adjourn a hearing, it is related to adjudicative duties. I don't want to, spend time on this right now. We'll leave it alone. Unless anybody else feels strongly, we need to move on.
The only thing I would say now that Chuck brought up the issue of it, I know in the past there were hearings conducted by the law board staff. So if that were to occur again in the future, are there other rules pertaining to when that existed, or is this the one spot where this is mentioned? Do you know, Chuck?
I'd have to look. When we signed on for oath, we went through and added or oath, all these, I'd have to look at all of the sections of section 127 and the other adjacent sections.
So we'd have to, if that were to occur in the next administration or something, they'd have to change a lot. We'd have to change a lot of the rules that mention and everything else.
I think you're right, Julie.
Those rules already exist. All the old rules that we were reviewing earlier today, those were all intended to apply to a scenario in case that there are a hearing officer again at the law board.
Okay, thank you.
But trust me, it won't be happening anytime soon.
Okay, are there any other comments? Okay. All right, so we'll move on to item number 6. Okay, so the law department for item number 6, they just wanted to make sure that this language was correct.
So, Mr. Clark, for the purpose of those who are listening from the public, they don't have this document, could you just talk about what section 6 is?
Sure.
I-
This statute is
It's subdivision B, section C,
section 13. It's section 2-05 B13.
okay.
Okay. So in a previous, this has to do with putting up the notices that a building is an IMD. And we had
Coconut water, it's done.
sorry. Did the chairperson want me to hold on for a second?
No, go ahead, I'm sorry, go ahead.
Oh, okay. So in a previous board meeting, we had discussions about how the loft board notice that a building is an IMD. We put in additional language in our rules about where this notice should be placed, and how the owner should make sure that the IMD tenants, when the occupants of the building, know that it's an IMD building. So this new language here is what Helene tried to propose to satisfy the board members. So that's the first part that's in pink, is Helene's language. And the second part for 13 is the current language. So what Oath wanted to do was make sure that this language that Helene put in here adequately represents what the loft board wanted. And the staff members looked at it, and we feel that this is what the loft board wanted, and we're fine with the language here. We just want to confirm with you all. This is for the notice. Are there any comments?
One thing that I notice is, and refresh my memory, we define day in the definitions, correct, as being a calendar day?
Well, we have a business day in our definition. A business day means 9 a.m. to 4 p.m. on Monday through Friday, except for federal, New York State, or New York City holidays.
Well, that's helpful. No, because as I recall, we went to great lengths in the rules themselves to take out business day and calendar day because we'd agreed on what a day was.
I remember those discussions. I don't remember. I don't know if that was ever, if the previous executive director ever put that into the definitions, but I don't see it.
The reason I bring it up is because here we have business day capitalized relating to the term, but a business day, I think business day in the definitions on page 6 of the draft that went to the law department means 9 to 4 o'clock. It's really talking about the business day of the law board.
Right.
Where are you, Mr. Delaney?
I'm on page 6 of the draft that went to the law department back in the summer. in the definition section.
Right, a business day and business hours, right? 9 to 6, Monday to Friday, except federal holiday, and business hours. So it seems that business day means a business day, which is Monday to Friday, as defined here. But business hours is referring to the New York City Loft Board business hours. A little sloppy, I would say, right there.
Yeah, and here we
well, maybe not. I'm sorry, Mr. Delaney. 1 second. I take that back a little bit. I think what they're saying here is that a business day. Oh no, go ahead. I'm wrong. Go ahead.
As I recall, we made a conscious, and Elliot, I would hope you'd remember this. In the rules as they exist now, there are places where it says calendar days, places where it says business days, places where it just says day. We all agreed, I think, that when we say day, it means calendar day. And I don't know of that many places where we call out business days.
Yeah, that was my understanding.
And I certainly don't understand, since we define 9 to 4 Monday through Friday as business hours, that makes perfect sense to me. So you've got to deposit, it has to be received by the loft board within its regular business hours. But if business day is a way of counting days, then why we have it defined as 9 to 4 p.m. makes no sense to me.
So this is all to do with the time that we give people to post, owners to post certain notices, right? And after an order. So can it just be days here? Do we need to define days?
Maybe we're trying to give them a break or give them a certain. What if we just said 7 days?
And you're saying days is not defined, Mr. Clark, right? I don't see it either.
Right. Days.
Right. And you probably don't need to define it if it's just days, right? It's business days and business hours. It makes a big difference in terms of defining it. But yes, I would go along with that, Mr. Delaney. Just make it days and make it 7 so that there is no issue about business or whether it's taking into account holidays, because most of the times, unless you happen to be lucky or unlucky, some weeks may have a holiday in addition to the weekends, right? So let's just make it 7 days.
So I will say in other places in the rules, we do specify calendar days and business days. So if we leave this portion silent, it could create some ambiguity of whether we meant business days or calendar days. Someone could argue they get 7 business days when we say days. So if you want to limit the ambiguity, I would say that we put down 7 calendar days, as we do in other sections.
Are you sure we do that in other sections too?
Yeah, I'm seeing it. Let's see, under 1-29, we say calendar days for adjournments. 1-32. I see calendar days throughout our rules. We also refer to calendar days when we define months.
I thought our goal was to get away from business days. And my recollection was we just use days. But if we're using calendar days, that's fine too. We just should try to be as consistent as possible.
And in this particular instance, I think it was meant to be calendar days, right?
I think that would make more sense.
5 business days, but if we change it to 7, I think that would pretty much even out to 7 calendar days, notwithstanding holidays.
Okay, that sounds simple enough, and I appreciate that, Mr. Delaney. 7 calendar days, Mr. Clark. Could we just make a note of that?
Sure. Okay. Are there any more comments on this issue? If not, then we have issue number 7. So issue number 7 is under 2-07, sale of improvements. Here, units are being defined under this section. Now, the issue the law department has is the law department thinks the term unit defined here is inconsistent with the global definition. Unit is not defined in our global definition, but we do have a definition for residential unit, and that's very specific, as opposed to unit. So the law board staff said, we only define residential unit in our global definitions. We do not think adding a global definition, we do think adding a global definition will be confusing if we add a global definition just for unit. Because there are other places we use the word unit. We'd have to just be very careful throughout our entire rules wherever we use unit, if we're creating a global definition for unit. We think we should leave this section as is or delete this part as unnecessary. The reason why we feel that this might be unnecessary is because further on down in the rule in 2-07, we think the reason why our rules want to define unit here is because for purposes of sales of improvements, formally a unit that is formally registered as an IMD is still included as a unit. So we wanted to make that very clear in this section, that you can have sales of improvements for units that were formally registered as IMDs, but were subsequently been legalized and removed from the law board's jurisdiction. So former IMDs removed from our jurisdiction can still be subject to a sale of improvement. So we think that's why they wanted to include that specifically in our rules here. But we do mention it later on in that same rule. So we think it might be duplicative. Further on down in the rule, in section 2-07B, for the right to sell, it says the residential occupant of an IMD unit, which is qualified for protection under Article 7C, may sell the improvements of the unit to the owner or to a prospective tenant, either before or after such unit has been legalized and registered with DHCR, subject to the procedures established in these rules. So we think we can either take out the definition of unit here or just leave it as is. That might have been a little confusing, but if anybody has any questions, I'll try my best to clarify it.
I think I suggested to you that we should put the word either residential or dwelling before unit. Well, once again, I'm not a lawyer, and you look up a definition of unit, it has nothing to do with a living space. So I would just include either residential or dwelling prior to unit and let it go with that.
Mr. Barris, are you saying for this particular section, put residential or dwelling in front of unit, or in the global definition? We have in the global definition residential unit already defined.
I know it. That's right. But then when you just get to unit with this particular area here, it gets a little confusing. Like,
Yeah.
What is the unit? Now,
So,
we know No, it's either a residential unit.
Mr. Clark, does the definition, the global definition of residential unit conflicts with this definition?
It does to some degree because the definition is just residential unit means any space used for residential purposes within an IMD building. So, for example, in my building, which had 3 residential units that were covered as part of the interim multiple dwelling, the landlord later created a 4th residential unit that has never been covered by the loft law. But if you said residential units it can sell fixtures, there'd be no way to differentiate that.
Agree.
Okay,
So-
guys, I mean, lawyers, I mean, do you have any suggestions?
So
I
we
think my
suggested.
suggestion.
Oh, go ahead.
Sorry, Mr. Clark, do you want to go ahead?
No, go ahead.
I think we should try to ask the law department to let us keep this section as it is. Section 2 is, I would prefer to do as little changes to as possible. As far as I can tell, what we've done to section 2 is change some capitalization and to incorporate a 2019 change in the law. And that's the way I think we should push the law department on for now. And it's just explain to them, yes, we recognize there are some aspects of section 2 that needs work, and we will get to that as soon as we pass section 1. I'm hoping that's sufficient. If we get a lot of pushback and say, no, you must take it out, then we should just take it out. But those are the 2 alternatives. I think one, option A, and if that doesn't work, we have a backup option. Just take it out altogether.
So Ms. Lynn, if we, I mean, the law department is only going to opine on stuff we give them, right? If we decide not to do it, not to change it, leave it as is, law will have no reason to comment.
Yeah, I suppose that's true. If we don't change anything in 2-07, because I believe this only went to the law department because we changed some capitalization to fit within the global definition. I don't believe there are any substantive changes to 2-07.
Right, and we can do those, fix those later, right, when we get to chapter 2.
Possibly, although then you would have just one section that doesn't refer back to the global definitions, which might be a little confusing. Because throughout chapter 2, we did.
But it kind of goes back to
global definitions.
It kind of goes back to global definition. It just doesn't capitalize the words, the words. For the first letters of residential unit, right? You still have the word residential unit is an IMD in an IMD building. It seems that we're just fixing this because we have global definitions for these now. But if we left it alone, it still reads that way.
Yeah, it still reads. It would just not, right, it would just be in lowercase. It doesn't go back to the global definition. It would be, right. I guess, technically an undefined residential unit.
But does it confuse? Does it add any confusion if it doesn't go back to the global definition?
I don't think so. But I suppose someone who's being very pedantic and reading through these rules very carefully and who wants to nitpick can say, look, you guys capitalize residential unit in 2-06, but not 2-07. This must mean something different. So yeah, you could definitely make a legal argument. I would have to think about it more to see whether it'd be a successful legal argument, but I think they could certainly try to, make some arguments about that.
So, Mr. Clark, I hate to be the one asking these questions because I didn't, but when the law department said, I don't see the point of this, it also conflicts with the stated definition. What's the conflict?
So I think the conflict here is that in the global definition of residential unit, there's the implication that it's tied to an IMD, a current IMD space. In the global definition, it says any space used for residential purposes within an IMD building. And then here in this section, we go on to define only units specifically, and then it encompasses units which have already been removed. It talks about formerly registered IMD unit, and that creates a bit of tension between these two definitions.
And your suggestion?
Go back to the law department and ask them to please let us keep it. We know it's confusing, but we will fix it in the next round, we promise.
All right.
But maybe we can, I'm just wondering if.
When you say keep it, I'm sorry, Julie. When you say keep it, meaning don't even include this in the rules.
Just leave
no,
it as
I meant
is.
just leave it as this. He says, I don't understand the point of this, and we'll just go back and explain. This is what's been written in our law board rules. We know there might be some tension between this and the global definition, but it's existed this way, and we're hoping to just keep it as it is and fix it in the next round.
Let's try that. Go ahead, Julie.
I was just wondering if we could fix it now by, I like little I and little double I, however you call it. But in the second one, could you just highlight residential unit, call it formerly registered or former residential unit, and underline residential unit in that part 2, so that they're related to each other. One's a former one and one's an IMD residential unit, and it doesn't seem like that confusing to me if you do it that way. If that makes sense to you. Did that make sense?
I think the definition of unit here would still conflict with what's in the global definition. It seems like the implication set by the global definition is that a residential unit is the current IND unit. But then here we go on to say a unit means something else.
Right. So so embedded in the residential unit global definition is that it's current. So if we included that in little II, we'd be saying formerly but current at the same time. Does that make sense?
Yeah, but can that be okay? I mean, it doesn't seem that off. I was just wondering if the unit at the top of 3, if we wrote residential unit and then little I says residential unit and little double I, whatever, says former residential unit. I mean, I like how clear it is about the I and the double I. It's clear to me. I never understood that, but I'm sure that's a very rare, the double I is probably a very rare situation, but it's good that it's included here. I just, I don't think it's worth redefining residential unit in the global definitions, nor is it worth taking this out completely because it's useful information. We could do it with what you were saying, just deal with it later, but it seems like kind of we could tackle it right now.
So you're saying the little I would read for purposes of sales of improvement governed by this section only, formally registered units as an IMD unit?
Yeah, I think what I'm suggesting is maybe if we have a residential unit underlined in both I and double little I, that you could make a clear connection that, okay, it's residential unit and it's former, and that's the only difference. That's what we're saying is the only difference.
Right. I think the law department's objection to this is the fact that we try to define unit at all in a way that he feels is contrary to how we define residential unit in the global definition. He seems to feel like if we define the word unit to encompass a former IMB unit, then it's problematic that we have in the global definition, the definition of residential unit is only current units.
Okay. Yeah, I see that. Is there any other case where a former residential unit has any other rights besides sale of improvement?
I would have to look into it more. Nothing comes to mind. Stefan?
Yeah, nothing comes to mind. I think this is the only time that comes into play. And it does happen sometimes. We've had sales of improvements come in after a building was removed from our jurisdiction.
So maybe we could try adding the word qualifying to qualifying unit to make it a different definition. Maybe that was, if that works.
Qualifying residential though, right? Because sometimes there's commercial units that, like, I've noticed sometimes things flip back to being commercial unit within a residential IMD building, right? But I don't know if it can.
Right. If you put qualified there, then little I would say a residential unit. So it would define it as a residential unit as opposed to a commercial unit.
Okay. And you'd have to then put the qualified unit in the global definitions?
Probably, yes.
I'm not sure if we have to. I guess it depends. We might have some flexibility there because this really only applies to this one section.
Yeah. Right.
But it's not a big deal to add one more definition to the definition, global definitions, is it?
I think maybe the only I might check the rules again. The only potential conflict I could think of is we might use qualifying a unit in other sections. I would have to check the rules again. I'm not sure if those specific words pop up anywhere else. Whereas I think if we try to limit it as a qualifying unit under this section is defined as X, Y, 3I and 3.2, 3II, that might work.
Yeah. I think so. I think we're almost there. I just want to complete the task, but I see what you're saying. You have to check if qualified unit is cross-referenced anyway. If you could do that, that would be great. I think we can almost get this one off. I'm just trying to check things off the list like you are.
Right. So we can certainly do some more research into this item. We can check the other section of the rules to see whether we use qualifying item unit anywhere else, and we can see if adding qualifying unit here would change this section specifically in some way. So we can table this and bring this back to the board at a future meeting after we do some research into it, if the board is amenable to that.
Yes, sounds good to me.
Anything to kick the can down the road and get a little more.
Not what we want to do here, but I guess we do. Tina, could you check your email and get back to me on something?
Yes.
Okay, so let's move on, Mr. Clark.
Okay. Item number 8. This is something that relates. This is language that relates to the MDL section 282-A. And what we're doing is we're removing this language because the law changed and it makes this language moot. So we just wanted to bring that to the board's attention, that we would be taking out this language because the law changed and completely removed this language, so we don't need it in our rules. This one was pretty straightforward. But if there's any questions, I'm happy to answer. And if there are no questions, then we have one more item on
Can
the
you
list.
just give me a minute while I look at
Sure.
page 127?
Sure.
Thank you. Yeah, it doesn't seem to be needed.
So we just deleted that and wanted to bring that to the board's attention. Does anyone else have any comments on this deletion based on the change to the law? It was no longer required, so we deleted the G in here. Okay, so there's no other questions. We'll get to the last item, which is under section 2-08 for coverage. There was some deletion here under section D, and we felt that the deletion was correct because it was later on put back in as section F. So if we look at the language, I'm sorry, it's put back in after section F, underneath F. If you look at it in the on the Word document, the language that was the strikeout in section D was put back in after section F. And I'll just leave it open if anybody has any comments.
I had a question, if you don't mind, just because you're more in the details here. What's the value of moving it to furthermore issuance after F? Like what
Just
does
for clarity. Yeah, just for clarity.
clarity? These are all certificate of occupancy issues, it looks like. That I'm just trying to remember what is this, what's the point? The larger point of why they're all just
So this particular rule relates to some buildings come into our jurisdiction with a certificate of occupancy already. And so this just speaks to them as to what buildings would be exempt from coverage and what buildings would not. There would be no basis for exemption. And with that, if there are no comments, Chairperson Hilton, we are finished with the discussions for today. That what I have prepared, and would like to thank the board members for their comments.
You did a great job. Thank you very much.
Yeah, absolutely. Thank you so much, Mr. Clark. And you were actually, you got the timing down right. Like you could estimate how long each board member approximately, will speak for and all that stuff. And you got us down at 4:30. Very nice. I am going to ask, does anyone have any other questions? Anything else that just want to ask before I close the meeting?
I have one observation and one question. The observation being that I will, in the next couple weeks, provide you with the language I propose for a resolution regarding the certification issue that we discussed and agreed to put on the agenda for January. And the question I have is, where can you help the board members get a sense of where we are with how we're going to get through the rules? It seems that things are coming back from the law department in dribs and drabs. Do we have a sense whether we've gotten 90% of their comments or only 60% of their comments? Do we see a roadmap for wrapping things up with oath? I know you've got a few things to research.
I will let Lynn.
I can speak to that.
Go ahead.
Well, I'll speak to the best that I can. So we don't really have anything outstanding at the law department per se. These comments that we've gotten back from the law department, these were follow-ups that we initiated based on the board members' comments to us. So the law department was done with their review, and that is still the state that we are in today. I will say in the past, I've gotten a couple of emails. This is an ongoing effort, not just for us citywide. When they do a rulemaking, an issue might come up citywide that they would feel is relevant to us, and they'll reach out and let us know. But short of developments, there's nothing outstanding from the law department at the moment. I don't believe we need to go back to oath on anything that we discussed here today. What is left on the oath portion is for the board members to approve of the language, which I recognize needs some research from staff to better inform the board members. So that's where we're at with that portion. So what's up next is for the staff to research those two oath items to better inform the board. And then we can also do line by line changes of the rules. So as I think I previously mentioned, there were some language changes done to the rules that were comments that basically changes from operations, and then operations sent their draft to law department. So the draft that we got back already incorporates operations comments. So in order for the board to see the full picture of everything that's been changed since you all last looked at it in February when you sent it out for review, we have to do merge these documents together and look at it to see what's been changed. This next portion is it is very dry, but there won't be any debate issues for that portion. It's just language changes.
So I know we've now discussed all the comments that we went from having a document with all of the law department's comments to kind of dealing with excerpts. And I don't have a clear sense whether the excerpts have covered all the comments, but is that indeed the case?
I believe it is. I'll have to ask Mr. Clark. He prepared the comment sections, but I believe these excerpts we pulled all the comments that law department made that we thought would engender discussion with the board, so we can tackle the big ticket items first before we move on to the smaller things. Mr. Clark, can you remind me whether we have any outstanding comments from the law department we have to discuss?
We spoke about all the outstanding comments from the law department, and as Acting Director Lynn stated, the remainder of the comments from the law department are smaller issues. We basically pulled apart the bigger issues that we felt required some discussion and the board members' attention, and then now the smaller issues we'll be going over.
And will those smaller issues come to us for review?
Yes.
Okay.
So
there's.
Oh, I'm sorry.
So there's more things that we need to discuss, although what we went through today are things that you would deem bigger ticket issues.
Correct.
So follow up with Ms. Lynn. What do you think? February we should be able to give the board members a final together of whatever we have. Should be? Do you think in terms of timing? Do you think February is a good estimate of when we can actually give a completed document to the board members so we can kind of make it formal?
Well, I think it would have depended on the January meeting and how far we're able to get on the oath portion, because there's still some portions that I know we don't have the approval from the board yet. If the board is okay with it, then we can certainly put together a new draft. But those are the things that are outstanding that would require the board to give us a yes or no on.
Okay, Mark?
We'll have to research yeah, I mean, depending on how board discussions go.
Okay, you hear that, board members? Okay, good. I'm sorry. We'll be offline, Ms. Lynn. I'm just joking. But that's really good news in terms of how far we've come, and it seems like we're seeing some light at the end of the tunnel in terms of rulemaking. As to the extent of what we've been trying to do for the past, I think it's now 3 years. Is it 3 years?
At least.
Yeah. Okay, any other observations?
To tag along to that, and I'm sorry, I may have spaced out a little some of what we were just saying, but you had mentioned previously about 30 minutes ago that the narrative statement chapter, was it chapter 2? You were saying that there were some issues there. That one seemed heavy with things changing. Are we reviewing that on a certain calendar day?
No, so the entire chapter 2 hasn't really been changed. There's been revisions to it that is supposed to be minor, just in terms of capitalization, so we can reference the global definitions and to update and incorporate the 2019 law. But there needs to be an overhaul of all of chapter 2, but that's not going to come until we finish this round of rulemaking, and then we'll start back up.
Oh, okay. Does everyone understand how that works? I don't quite understand. So one round of rulemaking, and then we go back to this narrative statement chapter later? When does that?
Well, yeah, there is. We'll probably take a little 6-month break between then.
Oh,
okay. This is not something we're going to rush right into. Yeah, but that definitely needs to be done. Of course, it's up to the board.
So is it two public hearings then? When?
No. Okay. So in terms of procedure, and Tina, please jump in if I'm wrong. But what I'm trying to get at is to get you guys a final, all this discussion into one final document where you can review and vote on, and that this is your final document to be sent to the law department for certification. Right, Tina? So far?
Yes. Yes.
And once the law department certifies it, it comes back to you, right? And we'll schedule a public hearing, correct? No, I'm sorry. Let me get that right.
They have to vote it out for a public hearing.
Voted for public hearing, finalized, you guys vote on it, and sent back to the law department for certification, correct?
Well, Yes, we need to get certification before we can vote it out for a public hearing. It's up to the board members
great.
whether they want it again.
Right, so I was right the first time. So if the law department certifies, it comes back, then we send it out for publish it for public hearing, and we have a public hearing, and then you guys will make the board will make any kind of modifications that they need from the public hearing, or vote to not make any changes, and then it goes back to the law department, right? Does it? Or just gets published?
Well, I guess if the board makes changes, the law department will have to look at it again.
Right.
And operations as well. I keep saying law department, but we need both to sign off.
Right. But if no change to the board, then the board votes on it becomes public 30 days. Excuse me, it becomes a law final 30 days after the board gives its final vote.
So where does the narrative statement work fit into that schedule? You just named like 4 steps.
The narrative
Any
statement?
revisions done to chapter 2 would be done after all of this is done. After all this is over, that would be for the far future to start another round of rulemaking. It would not be part of this, what we're discussing right now.
So the narrative statement is staying the same as it's been always, right now.
Anything in chapter 2, it's pretty much the same.
Okay. Thank you. Thank you.
Okay, I think I'll get, like, procedurally, I'll just clarify that the next board meeting is, you guys will be clear as to how we proceed with this whole thing when in the coming year. Okay, I want to say this has been a heck of a year for everyone. I really do appreciate, first of all, I want to say thank you to Ms. Lynn and her staff, taking us through this whole pandemic with adjustments to operations, adjustment to procedures, we haven't skipped a beat in terms of what we do at the Loft Board. We've continued, and we've been able to continue on right what we're doing right throughout. And so a lot of kudos go to her and her staff for continuing the work of the Loft Board in difficult times. And I want to say thank you to the board members for adjusting what you do normally and agreeing to all these types of different types of meeting coming on, online conferences and so on. It's been quite an adjustment for you too. I know you have your own family matters to attend to and your own personal safety during this time. And everyone really pulled together, and I'm very, 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 very proud of all of you and the staff and the board members. And I thank you so much for a very impactful year, or what would have been a very impactful year has not really impacted the Loft Board in so much in what we do. So thank you, thank you, thank you. I want to say again, welcome to Ms. Rajan, new board members, our newest board member. But I want to also wish everyone a very, very safe holiday season. This is one in the record books that you guys, if you don't have grandchildren yet, you just write it down. You have stories to tell. But thank you guys for everything, and just be safe. Enjoy the holidays. Merry Christmas, Happy Kwanzaa, Happy Hanukkah, and for those who don't celebrate, just have a great end of the year celebration. Happy New Year. The next time we meet, I'll talk about that, but hopefully by the next time we meet, you will get to be introduced to our newest board member, Mr. Christian Hilton, who is no relation. Christian Hilton, the newest real estate representative appointed by the mayor today. I didn't let you know this because it came in the middle of the meeting, and we'll get to meet him, and I'm sure we'll have a bio or something like that to share between now and then. His name is spelled Christian, like Christian, and Hylton, like myself, but as I said, no relation. Okay, this will conclude our December 10th, 2020 Loft Board meeting. Our next public meeting will be held on Thursday, January 21, 2021 at 2 p.m. The governor's suspension of the in-person meeting requirement of open meetings law is still in effect until January 1, 2021. At that point, we will know whether we can conduct our next meeting virtually. Board members, we will update you as soon as we know the format of our next board meeting, and we'll post that information to the Loft Board website as well as the Loft Board listserv that I'm hoping everyone has gotten already and started to. We got that listserv going. So if you're not on that listserv where you got a notice of your thing, you'll get it. Good. Board members, please sign and mail in and email in your attendance sheet. Thank you very much. Have a happy holidays. Happy New Year to everyone.
Thank you. Happy holidays to you too.
Thank you.
Happy
So long,
20.
everybody. Stay safe.
Happy end of this horrible year.
All right. Thanks, guys.
Take care, everyone.
Bye.
Bye.